Imagine this. You pour everything into starting a new business. It's your dream, yeah. And it's part of this big empowerment initiative. You're building something real, not just for you, but maybe for your community too. And then, bam, a seemingly tiny mistake, a missed deadline could just destroy it all. What happens then? I mean, what does the law actually do when your whole livelihood is hanging by this, thin thread? Okay, let's really get into this. Today, we're doing a deep dive into a really significant South African legal case. It's Beadica 231cc and others v. Trustees for the time being of the Organ Trust and others. Went all the way to the Constitutional Court, top court. Our mission here is to take this pretty complex legal fight. It touches on contract law, constitutional values, social justice, all that heavy stuff, and make it, well, genuinely fascinating for you. It doesn't matter if you're a law student or just someone who likes to know what's going on. We're going to unpack the legal issues, the arguments, how the courts decided, and, the bigger impact.
It really is a huge case because it tackles that core tension, doesn't it? You've got the idea that contracts or sacred pacta sunt servanda agreements must be kept, but then you have these evolving ideas about fairness, constitutional values, especially in a country like South Africa that's trying to fundamentally transform itself. It's like a snapshot of the legal system wrestling with the past and trying to map out the future.
Absolutely. So let's paint the picture, set the scene. Who are the main players in this business drama?
Right. So you've got a few key groups. First, the applicants. These are 4 closed corporations: Beadica 231, 232, 234, and 235 CCs. And the people behind them, the members, they were actually longtime senior employees of another company, Sales Hire.
Sales Hire CC. Okay, and they're the franchisor, right? Renting out tools and equipment. And the sole member is this Mr. Sean Sale. Now, remember that name, everyone. It's going to be important.
Very important. Then there's the Organ Trust. They're the landlord. They own the buildings where these Beadica businesses were operating. And here's the kicker, Mr. Sale. He's also one of the 3 trustees of the Organ Trust.
Wait, so he's the franchisor and effectively part of the landlord setup?
Exactly.
Okay, that already sounds like maybe a potential conflict of interest down the line. And who else? You mentioned the fund?
Yes. The National Empowerment Fund, or the fund, they're crucial here. Set up by law, the National Empowerment Fund Act, specifically to boost Black economic participation. So supporting businesses run by historically disadvantaged people, they were the ones who financed the applicants' businesses. It was all part of a Black economic empowerment, a BEE initiative. You really need that context to grasp the stakes.
Okay, so how did this whole thing get started? It sounds like, on paper, a really positive initiative.
Oh, it was meant to be. Back in 2011, Sales Hire teamed up with the fund. The deal was, the fund provides loans to Black-owned businesses, like the applicants, so they can own and run Sales Hire franchises. And Sales Hire, they were supposed to provide training and, importantly, ongoing business support and mentorship.
Like a whole support structure. Okay, so the applicants, they signed these 10-year franchise agreements in October 2011, and they had to operate from specific approved locations?
Precisely. Now here's where it gets tangled. They also signed lease agreements, mostly identical, with the Organ Trust. That was back in May 2011. These leases started August 1st, 2011, but they were only for 5 years, ending July 31st, 2016.
Wait. 10-year franchise, 5-year lease? That seems mismatched.
Well, there was a plan for that. The leases had this really critical clause, clause 20.1. It gave the applicants an option to renew for another 5 years, so that would match the 10-year franchise term.
Okay, that makes sense. But there was a catch, I assume.
A big one. A very strict condition. They had to give written notice to renew at least 6 months prior to the termination date.
6 months before July 31st, 2016. So the deadline was January 31st, 2016. Crystal clear.
Crystal clear. And, well, you can probably guess what happened.
He missed it.
They missed it. None of them exercised the option by January 31st. One of them, the second applicant, sent absolutely nothing. The other 3, they did send notices, but only after the deadline had passed, in March 2016.
What did those late notices even say? Were they like, oops, we forgot, can we renew?
Not quite that direct. They were a bit varied. For instance, March 3rd, the 4th applicant's accountant emails the trust, asks how soon they could get a new lease draft for discussion purposes. Then March 15th, the 3rd applicant sends a letter. It's mostly an offer by the property, actually, but tacked on is a request for a draft of the renewal of premises lease. And then March 29th, the 1st applicant sends a letter asking to propose a renewal on our already existing lease agreement, maybe with an option to buy.
So they're clearly signaling they want to stay, but late. And maybe not as definitively as just saying, we hereby exercise our option. How did the trust respond?
Well, for a few months, nothing seemed to happen. Then July 2016 rolls around, right when the original 5 years are up, and the trust formally demands they vacate the premises, leave.
Wow. Okay. And the stakes for these applicants, for these businesses they'd built up with fund money.
Huge. Everyone agreed. It wasn't really disputed. If they got evicted, their businesses would almost certainly collapse. And that whole BEE initiative, the reason the fund invested, it would fail. Gone. I mean, sales hire could maybe let them operate somewhere else, but that was totally up to them. No guarantee. So the whole point of this empowerment project was basically on the line because of this missed deadline.
Facing, as someone later called it, capital punishment for their businesses, so they had to fight it. Where did the legal battle start?
They went straight to the High Court, urgently. They asked the court to declare that their renewals were valid, essentially. Their argument was that strictly enforcing that deadline clause in these specific circumstances would be contrary to public policy, or maybe unconscionable, unfair, basically. The trust, of course, filed their own application demanding eviction.
And the High Court, what was their take? Strict contract law or the bigger picture?
The High Court actually sided with the applicants. Big win for them initially. They declared the leases had been validly renewed and told the trust they couldn't evict them.
Really? How did they justify that? I mean, the deadline was missed.
Yeah, it was a bold move. They leaned heavily on a previous constitutional court case called Botha. They interpreted Botha as bringing this idea of a principle of proportionality into contract law. Essentially, they said kicking them out would be a disproportionate sanction, too harsh a penalty for just missing the date, especially given the catastrophic consequences for the businesses and the whole BEP project, like using a sledgehammer to crack a nut, basically.
Okay, focusing on the outcome, the fairness of the result. But then it went up to the Supreme Court of Appeal, the SCA. They tend to be more traditional on contract law, right?
Oh, yes. The SCA was not impressed with the High Court's approach at all. They came down hard, emphasizing cactus sunt servanda. That core idea, agreements freely made must be honored, period. They talked a lot about the need for certainty in contracts, especially for business. Predictability.
So they were pushing back against this idea of judges deciding based on what seems fair in the moment?
Exactly. They acknowledge, courts can refuse to enforce contract terms if they genuinely violate public policy, but they stressed that power should be used sparingly, like only in the clearest of cases. They totally rejected the High Court's disproportionate sanction idea, called it entirely alien to South African law, said it would just undermine the whole legal framework.
So for the SCA, the missed deadline was the end of the story?
Pretty much. They found no public policy reason strong enough to override the clear terms of the lease. So they overturned the High Court's decision and ordered the applicants to be evicted.
Ouch. Back to square one, and worse. So their last hope was the Constitutional Court.
The highest court in the land. And this appeal, it wasn't just about these 4 businesses anymore. It became about this fundamental question. How does contract law fit into South Africa's constitutional democracy? It was a massive opportunity for the court to really clarify how things like fairness, reasonableness, good faith, how they interact with traditional contract rules in this new era.
Right, the big picture. So how did the Constitutional Court, the majority at least, handle this balancing act?
Okay, Justice Theron wrote the main judgment for the majority. She laid out some key principles. First, public policy and the Constitution. She said, look, public policy isn't just some vague idea. It's deeply rooted in our Constitution and the values. Dignity, equality, freedom. So constitutional rights do influence contracts, but kind of indirectly, through this channel of public policy, not like a direct override in every single case.
Okay, so the Constitution sets the background values. What about those trickier concepts? Fairness, reasonableness, good faith. Can a court just say, this contract feels unfair, so we won't enforce it?
That was the core issue, really. The majority said, yes, these values are super important. They underlie and inform contract law. But, and this is crucial, they are not autonomous, self-standing requirements. A court can't just refuse to enforce a contract term because the judge personally thinks it's unfair, unreasonable, or unduly harsh. It's only when enforcing the term is so unfair, so unreasonable, so unjust that it actually becomes contrary to public policy informed by the Constitution that a court can step in.
So there's a higher bar. It's not just about subjective feelings of unfairness. It has to hit that public policy threshold.
Exactly. It needs to offend the fundamental values underpinning the legal system.
And what about pacta sunt servanda? Honoring agreements. Did they agree with the SCA that it's paramount?
They definitely recognized its importance, called it a profoundly moral principle, vital for the economy, for freedom, for dignity. But, Justice Theron added, it's not the only, nor the most important principle. That's a key nuance. When other constitutional rights or values are involved, you need a careful balancing exercise. It's not automatic that pacta sunt servanda wins. It needs to be weighed against other constitutional considerations.
So a balance, not a hierarchy. And this idea of perceptive restraint, that courts should tread carefully when interfering with contracts.
They agreed with the principle, yes, the power should be used sparingly, only in the clearest of cases. But they immediately added a warning. Courts shouldn't shrink from their constitutional duty to infuse public policy with constitutional values. That restraint shouldn't be used as a protective shield for contracts that undermine the very goals that our Constitution is designed to achieve.
Mm.
And they also push back on the idea that you only intervene if there is substantial and incontestable harm to the public. The test isn't quite that narrow.
Okay, this feels like they're carving out a very careful, constitutionally sensitive path. How did they deal with that Botha case the High Court relied on for the proportionality argument?
This was a major clarification. The majority said the SCA, and maybe the High Court too, had misunderstood Botha. Botha, they explained, did not rewrite the legal position on equity, in contract law generally. It had to be seen in its specific context dealing with a particular law, the Alienation of Land Act, designed to protect certain buyers. So Botha did not create a general rule that you can escape a contract just because termination seems disproportionate to the breach. The leading case on public policy and contracts, they stressed, is still Barkhausen, which takes a more nuanced approach. You look at whether the clause itself or its enforcement is contrary to public policy considering all circumstances, not just a simple proportionality calculation.
Okay, that's a really important legal point. So with all those principles set out, how did the majority apply them to Beadica's situation? Did they find a public policy reason to let them off the hook for the missed deadline?
Well, first, they looked at the burden of proof. The applicants, they said, had to show why enforcing the clause was against public policy. And that means giving a good reason for failing to comply.
And the reason was essentially, we're not sophisticated business people. We didn't fully understand.
That was the core of it, yeah. But the majority, agreeing with the SCA here, found that explanation just wasn't good enough. They pointed out the lease terms were clear and easy to understand. The applicants knew that they had to give notice. The only conclusion, they felt, the inescapable inference, was that they simply neglected to comply. Being inexperienced wasn't seen as a valid excuse when the requirement was so straightforward.
What about the argument about the whole BEE initiative failing? Surely that weighed heavily. The social impact?
They acknowledged the harsh outcome, definitely. The potential collapse of the BEE project was serious. But, they said, that harsh outcome alone, without a proper explanation for why they failed to comply, wasn't enough to refuse enforcement. In their view, the potential failure was attributable entirely to their unexplained failure to follow the contract.
And the trust's behavior. Mr. Sale wearing two hats. Did the majority think the trust acted unfairly, maybe took advantage?
They considered that, but they concluded the trust wasn't snatching at a bargain or sneakily exploiting a mistake. Their reasoning was that the leases ended automatically because the option wasn't exercised on time. The trust didn't actively cancel anything, they just let the contract expire as written.
Okay, and the final big argument, equality. Section 9(2) of the Constitution, promoting equality for previously disadvantaged groups.
Yeah, they looked at that very carefully. But they concluded that actually accepting the applicant's equality argument here could backfire. It might lead, they argued, to an undesirable result that actually harms the goals of BEE. Because, they reasoned, if courts readily excuse noncompliance based on historical disadvantage, it could increase the risk of contracting with historically disadvantaged persons. This might make potential partners or funders hesitant in the future, or force beneficiaries to accept worse terms to mitigate that perceived risk.
So paradoxically, it could undermine empowerment efforts.
That's a complex argument. So the final decision from the Constitutional Court majority was?
They dismissed the appeal. They upheld the SCA's decision. The eviction order stood.
Wow. So despite all the nuances, the bottom line was the contract, the deadline, had to be enforced.
For a majority, yes. They felt it was the necessary outcome to uphold legal certainty while still affirming that public policy rooted in the Constitution can intervene, just not on these specific facts.
But as you said, it wasn't unanimous. There were dissents, strong ones, from Justice Frohnman and Justice Victor. They saw things differently, right? Oh, very differently. Justice Frohnman's dissent, which Justice Madlanga agreed with, really went to the heart of the matter. He argued that deciding fairness in contracts is never just a neutral legal exercise. It always involves making an underlying moral or value choice. He felt the majority tried to find common ground, but ultimately couldn't bridge the gap without fully embracing what he saw as the core of the Barthusen decision. That public policy, especially when constitutional values are involved, has to be decided directly using fairness, justice, equity, reasonableness. These aren't just background considerations, they are the standards themselves.
So he's saying you can't just pay lip service to fairness. It has to be the actual measuring stick when the Constitution's involved. He didn't buy the SCA's rules like sparingly in clearest cases.
Exactly. He critiqued those rules sparingly. Clearest cases, incontestable harm, saying they were just as abstract and uncertain as the values like fairness they were supposedly trying to avoid. He then did this fascinating historical overview, showing how contract law has always grappled with fairness. From ancient ideas like liceo enormis, setting aside grossly unfair deals, to the modern era where unfettered freedom of contract has been challenged and changed.
So his point was, this isn't some radical new idea. The law has always had ways to temper strict rules with fairness.
Precisely. He pointed to things like implied terms, courts refusing to enforce contracts against public policy even before the Constitution, like in the Sasfin case, and laws like the Conventional Penalties Act. He argued that South African law already intervened in pure freedom of contract, and he made the powerful point that for most South Africans under apartheid, freedom of contract was meaningless anyway because of systemic inequality. He also looked back at Botha, arguing it was an example of good faith, allowing courts to relax strict rules to avoid unfair, disproportionate results. And he mentioned another case, Dunlop, where good faith was explicitly linked to promoting equality in unequal relationships.
That's a strong counter-narrative. Did he offer a practical way to apply these fairness standards so it's not just judges doing whatever they feel like?
He did. He suggested looking towards German law for inspiration, proposing cognizable standards. Yeah, this would involve checking for things like a clearly disproportionate exchange, where one party is badly prejudiced, especially if they were less able to protect themselves. It's an attempt to structure the fairness assessment.
Interesting. A more defined framework. And Justice Victor's dissent, she brought in Ubuntu, didn't she?
Yes, strongly. She agreed with Frohnman, but put a special focus on Ubuntu. She sees it not just as a philosophical concept, but as a substantive value, right alongside fairness, justice, equity, and reasonableness. For her, Ubuntu, emphasizing community, compassion, social justice, humaneness, has a unique power, a greater and context-sensitive reach, particularly where there's unequal bargaining power.
So Ubuntu as a concrete legal tool, not just a nice sentiment.
Exactly. She challenged the whole idea of absolute certainty in contract law, calling it a shibboleth, a kind of outdated belief we cling to. She pointed to modern laws like the Consumer Protection Act and National Credit Act, arguing that Parliament itself often prioritizes fairness and protecting the vulnerable over absolute contractual certainty.
And Mr. Sale's dual role, franchiser and trustee, how did she view that?
It was central to her reasoning. She highlighted this conflict of interest. Mr. Sale was supposed to be providing business support and mentorship under the BE deal as franchiser. Yet, as trustee of the landlord, she noted, he took no steps to advise the applicants to renew the lease agreement timeously. Instead, she argued, in conflict with his obligations, he was instrumental in launching the eviction. For her, this conduct just wasn't bona fide. It lacked the good faith expected in that relationship.
And she also used that striking phrase about the consequences.
She did. Echoing the High Court, she called the eviction a devastating blow, akin to capital punishment for these businesses, especially since they'd apparently worked hard and paid off their loans. Looking at that outcome through the lens of Ubuntu, fairness, and the Constitution's transformative goals, she found enforcing the strict deadline profoundly unfair in its implementation in this specific context.
So both dissenting judges would have found in favor of the applicants. They would have let them stay.
Yes, they would have upheld the appeal, essentially restoring the High Court's original decision, allowing the businesses to continue. Their focus was much more on the substantive justice of the outcome, viewed through constitutional values.
Wow. Okay, this deep dive, it really lays bare that tension, doesn't it? Between the predictability of contracts, pacta sunt servanda, and these really powerful constitutional demands for fairness, equality, even Ubuntu. It's amazing how one missed date could trigger such a fundamental debate.
It really is. This case is so much more than just a missed deadline. It's about the highest court in South Africa, wrestling with its constitutional job, transforming society, even when it comes to private business deals. And you see these two very different but both very compelling ways of thinking about how to balance individual agreements with those bigger social goals.
Yeah, it's a stark reminder that law isn't always black and white, is it? Especially when it crashes into our deepest values and, people's actual lives and dreams.
And that really leaves us with a question for you, listening. If even clear contract terms, like a deadline, can be weighed against fairness and social impact, what does that mean for the contracts you sign? Or for these big initiatives trying to fix historical inequality? What role do you think empathy, context, Ubuntu maybe, should play when the law has to make a tough call? Something to think about.